When you're considering what you want to trademark for your business, don't think about the law, think about your business. That is, what are your customers looking for when they're looking to find you? What names are they using? What logos are they looking for? What taglines do they expect to see? These are the items that you need to consider getting a trademark for, the items that your customers look for when they look for you. Conducting a trademark search is a very important step in the process of getting your trademark rights. One of the first things you need to consider is whether or not the brand that you've chosen presents any risk to you. That is there any third party that once they see you using your brand will try to stop you from using your brand, either via a lawsuit or some sort of USPTO action? Conducting a search is a very complex step. You need to look at a lot of different records to get a lot of information and then perform a legal analysis on the information you gather. The records you need to look at include the records in the USPTO database, as well as records in a lot of state databases, including state trademark records and state Secretary of State records, and the internet at large. You're looking for any brands that are out there that might indicate that there's some sort of a risk with you being able to use your brand. A lot of people are confused about the difference between use in commerce and intent to use. This is one of the few times that the law actually uses words that I think many people can understand once you understand what commerce means. Use in commerce simply means that you're currently using the brand. That is, that you're selling the good or the service that you intend to sell under the brand in the marketplace today. Maybe it's not as broadly as you intend to sell it, but you've begun the journey of selling. Intent to use is useful for companies that either have not started or for existing companies who are thinking about launching new service lines or new products. Those companies often have brand names that they've not started using in commerce, that they're not offering to the public yet to sell the goods and services they intend to sell. This intent to use system is the USPTO's way of allowing you to gain some rights in your trademarks prior to actually using them in the marketplace. That way you know that you can reserve the right when you are using your mark. The United States and every country on the planet is unified in one way. That is, they all agree that every good and every service ever sold in the history of business belongs in one of 45 classes. Confusing, I realize. The first 35 classes are for goods, that is products. For example, class 25 is for clothing, class 18 is for leather goods, class 9 is for software and scientific items. The last 10 classes are for services. The most common one is class 35, which is for retail sales. To determine which class your particular good or service that you sell belongs in, you can go to the USPTO.gov website and look at their list of pre-approved identifications. They have a searchable field database section for you to be able to type in what you're selling, and it'll list various ways that you could describe that, and it'll show you what classes these various things belong in. One thing that confuses a lot of people is often a good can belong in more than one class. Software, as an example, can be in class 9 if the customer is downloading the software onto their machine, or class 42 if they're accessing your software remotely. When you're filing a trademark application, you need to have several things available to you before you begin the process. The most obvious is gathering information for what you're going to be protecting. That is, what good or service are you selling? Do you have a description readily available? What brand are you actually trying to protect? If you're trying to protect something that is not just simple words typed on a computer screen, do you have a digital image of that brand to be able to present to the PTO? You also need a lot of information about who is seeking the protection. If it's a company, where's that company organized? What state are they organized in? What type of entity are they? And what is their business address? If it's an individual, where does that individual reside? What is their nationality? Getting all this information together ahead of time allows you to go through the application filing process much more easily. A lot of the items I've described in seeking trademark protection seem like they might be simple until you dig into them, in which time you realize there's a lot to cover. If you need help with this process, please reach out to us at Initiating Protection. You can call us at area code 678-965-3268.